Okay, this session is on Stephen Sax's paper, Originalism as a Theory of Change. We go from originalism as practice to originalism in theory with this paper. As Mike Rappaport said, unfortunately, Dick Fallon, who is going to be the commentator on Stephen's paper, had to cancel because of an illness in the family. So I'm going to wear both the commentator's hat and the moderator's hat, but when wearing the commentator's hat, I will actually not only not be channeling Dick Fallon, I'm actually going to be reading Dick Fallon because he sent his comments here. So you just imagine a kinder, gentler version of me as I read his comments. So now this is Dick Fallon speaking. I deeply
I would always be willing to cede pride of praise to Dick Fallon or his current incarnation, but I'm happy to give the presentation first.
All right, go ahead.
Thank you.
Potatoes are not the same person.
I was going to be the paper presenter as well.
So first, let me start by again saying thank you to all of you for coming, to Mike Rappaport and the other organizers for inviting me to speak, and in particular for all of you wading through a very long and very dense paper that is also very much in draft. This paper is not a finished product by any means, no matter what the formatting looks like. And please, I very much encourage basic and substantive comments and criticisms that could really use improvement. This paper argues that originalism is better understood not as a claim about the meaning of a certain text, but as a claim about the content of our law. Originalism assigns to our law an origin, a founding, and it holds that, once founded, the law stays the same until it's validly changed. In particular, it insists that, to be accepted as valid, any changes to our legal rules be legal, that they be lawful, that they be in accordance with law, that they're explainable on grounds within the legal system and not just outside it. We give the text a certain legal content today, not just because its meaning has stayed the same, though that may be true, but because doing so is the only way of preserving our pre-existing legal rules and of restricting to legally acceptable means the modes of legal change. Now, I'm not the first to make some of these points, even of the people in this room. But I think that emphasizing this aspect of originalism may affect how we think about some of its other aspects. In advancing the thesis, the paper has 5 goals. The first is to supplement traditional conceptual and normative defenses of originalism in favor of a specifically legal defense, rooted in widely accepted intuitions about our positive law. Second, to suggest, as one such intuition, the idea of legal continuity with the founding, that our law is the founder's law. Third, to present this continuity as plausibly true of our law, and to show that if it is true, it has recognizably originalist consequences, entailing sort of a broad form of original methods originalism. Fourth, to identify this grounding, reasons why this grounding of originalism may help resolve some ongoing disputes, both within originalism as a field and about the appropriate role of history in the legal enterprise. And fifth and finally, to give non-originalists a useful vocabulary on which to oppose originalism that clarifies some current disputes and may help the two sides talk in more productive ways. So in the time left, I'll say a few things about each. First, most current defenses of originalism take one of 2 forms. Either they're conceptual defenses grounded in philosophical claims about the nature of meaning and interpretation, or normative ones, arguing that originalist interpretation is, for one reason or another, a good idea. Both, I think, need to say a little bit more about our law. Different societies, as we know and as we will hear later, may say different things about constitutionalism. Some may be originalist, some may not. And when they read their legal documents in different ways, they might be doing it in a way we think of as wrong, philosophically or conceptually, but society's laws can be messed up in lots of ways. And who are we to tell them they have to do things differently? You could pose the same critique of normative arguments. Maybe originalism is a great idea, but there are lots of great ideas out there which aren't part of our law. Usually originalism is presented as what judges and officials are already obliged to do in some way or another, and not as a program for law reform, though it could be one. And if it were one, there are lots of other programs for law reform that might be higher on our agenda. My paper encourages a different kind of defense, a positive defense of originalism, as already required by our positive law. Now, the initial objection to this is that it sounds crazy. Look around you. Judges do lots of non-originalist stuff all the time. Clearly, originalism is not a good account of our law. As to that initial objection, I have a different paper, which may someday need to be combined with this one. It's forthcoming in Notre Dame. And I'll just discuss it very briefly, as I do in the paper here. And the basic position is that from a positivist perspective, we're looking for what are shared claims about the law in our society. And it may well be that there are higher level intuitions that are widely shared about the nature and grounds of our law, the justifications for legal claims, that in fact actually entail some form of originalism. That even if we disagree at the level of application, we might agree at higher levels, and that might have certain implications. I mean, the standard example for lawyers, everyone's familiar with the idea of cracking open the statute book and finding something you didn't expect. So, oh my gosh, 18 U.S.C. 711A says that it's illegal to misuse for profit the character woodsy owl or the associated slogan, give a hoot, don't pollute. Or the standard example from The Simpsons, where Chief Wiggum looks in the book and says, it's illegal to put squirrels down your pants for purposes of gambling. Knock it off, boys. So it may well be, those examples work because we have a shared intuition that the statute book is authoritative and that we're willing to make inferences from that to say that other practices that we thought were perfectly okay, in fact, are actually illegal. My claim, and it's developed elsewhere, is that this is a plausible way of looking at the world that could allow something like an originalist theory to be true of our positive law. And in particular, the role of this paper is to propose one such potential intuition, namely legal continuity with the founding. So on to the second goal, the proposing this intuition. This too might seem like a crazy idea. How could it be that we have the same law that the founders did? They had rules about horses and buggies and we don't, so ergo they're different. The response to this is to say that legal systems contain not only just substantive rules, like don't steal and don't murder and use horses and buggies, etc., but also rules of change. They specify how it's possible to alter legal rules without violating any legal rules. And because there are these rules of change, it's possible to have continuity over time, to say that we're part of the same, we have the same legal rules in some sense that they did, even though we have changed them, but we changed them in ways that themselves were according to legal rules. And the flip side of recognizing certain legal limitations on the accepted modes of change is that we accept that changes that don't satisfy these legal requirements actually fail to really be changes in some sense. Now, I might say that if Congress passes a statute that is not within its power, I mean, within the scope of its ability to change the law, that statute is void, and the law hasn't actually been changed after all. So what continuity says, the idea that our law stays the same until it's validly changed, until it's changed in accordance with law, is that when we're trying to give an explanation for why something is the law now, you say why it was the law as of some date X, and then explain what happened in between X and today to cause the new legal rule to be the case. The analogy I give in the paper is to something, the maxim nemo dat, or the idea of a chain of title. You had it then, and I have it now, and I can give an account of how it got to be from one to another. In particular, the claim in this paper, and I'm sure we'll say more in the Q&A, is that the idea is legal continuity from the founding. That we don't care necessarily about legal rules that pre-existed the founding. It would be okay, for instance, if a legal rule we have today just violates the Articles of Confederation and there's no good story as to how we got from one to the other while accepting and respecting all the legal rules throughout. But it's not necessarily true of things that occur after the Constitution. So we do have serious discussions about whether the 14th Amendment, for instance, was validly adopted, whether West Virginia is constitutional, whether the New Deal is, and so on and so forth. It's sort of plausible within our legal system to talk about those things in a way that's not plausible to say, was the Constitution validly adopted under the Articles of Confederation without actually having some legal consequence? one very common intuition that we have in talking about our law is saying that things have to be explicable in these historical terms, going back to the Constitution, but not further. So assuming that that strikes us as plausible, and the paper says much more about that, and I'm sure we'll have a lot about it in the Q&A, what does that mean for originalism? I think the picture that it generates is one of a very broad original methods originalism. The idea here is we're interested in what was the law at the time of the founding, and then how has it changed to today? And in finding out what was the law at the time of the founding, what we're interested in is not what the Constitution says, so much as what the Constitution did. What did it add to the legal system at the founding? What was its contribution to the stock of American legal rules as of its adoption in 1788? And to know that, we have to know all of the law that might affect how a text generates legal rules. Maybe back then the positivist looking at the society of 1788 would say they were original intention originalists, or they were X or Y or Z, or they were Straussians, or they were Ackermanians, or they had all of these different commitments about what texts do in law and what kind of legal rules they generate. And if something on the basis of those positivist discoveries was the law in 1788, the claim is that so it is today, unless it's been validly changed since then. So it's possible, in some sense, to assimilate all of these ostensibly non-originalist views about the content of American law, but in doing so, it makes them vulnerable to the historical claim that they're actually wrong about what the founders thought, and that the law of the founding, in fact, was something different, that that's how we figure out what the Constitution did back then and what it does today. If we buy that very broad notion of original methods originalism, it may, and this is the fourth goal, help us solve some of the problems within originalism and between originalism and other fields such as history. Within originalism, we have ongoing debates, which are discussed in the paper, between intentions and public meaning and different flavors and so on. On one hand, this view allows us to have a site of reference for this debate. It sort of takes the Jefferson-Powell critique and runs with it. What we really care about is the status of the law at the time of the founding and how it has been validly affected since. But it also might help particular problems within those fields. So for instance, original intentions originalism often has the difficulty of explaining what we do when there are multiple authors of a text and they have different intentions about what happens. It might also have the problem of very difficult to find evidence. It's hard to uncover those intentions reliably. The originalism as a theory of legal change might help answer some of that by saying, well, what legal rules did we have back then that solved some of these problems? Maybe there were legal rules that said, even if you had multiple potential intentions involved, here's what you do about them, or here's what you do in cases of uncertainty, or here's how you cash this out in other ways. Secondly, with regard to original public meaning, one of the big difficulties is motivating the choice of evidence that's going to be admitted. What things were publicly available? What do we even mean by that? What is the reasonable degree of, the reasonable person's knowledge about the law? And one way of motivating those choices, which are hard to do if what we're examining is meaning in the abstract and vacuum, is to say, well, we might have legal rules that say you're supposed to look to the ordinary meaning, or you're supposed to look to terms of art, or you're supposed to look to X, Y, or Z. Those are things that societies might actually have exercised choices over and have specifically legal conventions, not necessarily just common practices. So it may be that there are, in fact, legal answers to some of these problems that might help us solve them for today. In addition, this view of originalism might help explain some of the difficulties involving the role of history. It's often said that originalism is flawed because it requires lawyers to do historians' work. But if what we're actually investigating is the question, what was the law as of 1788? Well, that sounds like a lawyer's question. And as I say in the paper, we do that all the time in law. If we have an ex post facto question, we say, what was the law as of the time that the crime was committed? If it's a chain of title, what was the law when the grant was made to Lord Baltimore so that we know whether the Old Dominion Boat Club in Virginia is in the district or is in Alexandria? I mean, all the time we come up to these kinds of problems. And in fact, they're ordinary legal problems. It's not to say they're easy in any way, but they're ordinary legal problems that reasonably have lawyers addressing them. Finally, the last point I want to make, which doesn't come through in the paper as much, and I'd like to do this in draft, and I'd be curious as to your thoughts, the way in which this view of originalism as legal continuity of the founding might make for better non-originalist arguments in certain ways, because it allows non-originalists to put their jurisprudential cards on the table and say, okay, this is why I disagree. Yes, maybe the Constitution meant that at the time, maybe it did, but you know what? I don't care. There are other things that are part of our law today, and we don't necessarily worry too much about how they got there. Mitch Berman and Kevin Toe have written a great paper taking a view like this, and Dick Fallon has also, Henry Monahan. But these kinds of arguments are in some ways the most fruitful arguments for figuring out whether originalism is true as a matter of positive law today. But so it gives non-originalists a choice. Maybe someone like David Strauss, though not him personally, might agree that, like, yes, my claim really is that we had a common law constitution back at the founding, and so therefore we do today. Or they might disagree, that we didn't have one at the founding, but we did sometime in the 70s, and that's what we've got now, so that's the answer. If the argument is put that way, though, it might conflict with other intuitions that we have about how our law is made, where it comes from, what we think about it. It might be that stare decisis is less plausible if we say that it began in 1963 and no further back. And so it might allow for some disagreements that originalists and non-originalists have to be resolved based on these other kinds of complicated intuitions. Finally, I just want to say, as I say in the conclusion, that this view of originalism as legal continuity of the founding is at the same time both very complicated and very simple. It's very complicated because in addition to all the other kinds of evidence that we're used to looking at, like original meanings and sort of dictionary definitions, intentions, all those kind of things, we now also have to recover all of the legal rules for interpretation that they had and all their legal doctrines of change and what did they think about liquidation and so on and so forth. That's a huge additional volume of evidence. But at the same time, it's also very simple because it says that what we're really doing there is just asking the question, what was the law as of 1788, which is an ordinary legal question to ask. And that ultimately our law is the law of 1788, except insofar as it's been validly changed. Thank you.